A federal district court in New Hampshire recently granted provisional class certification and issued a preliminary injunction that would effectively block President Trump's executive order limiting birthright citizenship. This is directly related to the Supreme Court case Trump v. CASA, where the court held that district courts generally don't have the power to issue universal nationwide injunctions. So let's do a quick breakdown of what the Supreme Court actually said. This case began after President Trump issued Executive Order 14160, which aimed to narrow birthright citizenship under the 14th Amendment. The order denied citizenship to children born in the U.S. if their mothers were here unlawfully or only temporarily, and their fathers were not U.S. citizens or lawful permanent residents. 3 federal district courts blocked that order with nationwide injunctions. These injunctions didn't just protect the people who sued, they barred enforcement across the entire country. When the government appealed, it didn't ask the Supreme Court to decide whether the executive order was constitutional. Instead, it asked the court to limit those injunctions so that they applied only to the actual plaintiffs in the case. That was the central question. Can a federal district court issue a universal injunction? The Supreme Court said no. District courts generally don't have the power to issue such sweeping nationwide orders. Here's the court's reasoning. A universal injunction is an equitable remedy. District courts only have the equitable powers that Congress granted them in the Judiciary Act of 1789. The Supreme Court held those powers are limited to remedies historically available in courts of equity at the nation's founding. And back then, courts didn't issue nationwide orders. They granted relief only to the parties before them. The court also rejected 3 main counter-arguments from the respondents. First, they argued that the English courts had something called a Bill of Peace, similar to a universal injunction. But the Supreme Court said the Bill of Peace was only for small defined groups and was more like an early version of class action. Second, respondents claimed they needed a universal injunction to get complete relief. The court disagreed, clarifying that complete relief means protecting the plaintiffs themselves, not everyone nationwide. Third, they offered policy arguments in favor of broad injunctions, but the court held that policy concerns can't override the legal limits on judicial power. In the end, the Supreme Court limited the injunctions to protecting only the actual plaintiffs, but it left open the door for nationwide relief through class actions. The majority described the Bill of Peace as a historical precursor to modern class actions. In his concurrence, Justice Kavanaugh noted that plaintiffs challenging new federal statutes or executive actions can seek class-wide preliminary injunctions under Rule 23b2, which may be statewide, region-wide, or nationwide. That's actually the mechanism the New Hampshire court used when it recently issued its preliminary injunction, giving it the same practical effect as a universal injunction. So that wraps up Trump v. CASA. Let me know if you have any questions.